good afternoon, everyone, and welcome to Level 27 Chambers. We're very pleased to have you join us. If you're online by Zoom, hello. Watching us live as we go out to the world. If you happen to be watching us after the fact on YouTube or the like, hello to you also. And if you happen to be listening to us via our new podcast, which is entitled Briefed Commercial Law Updates, available at all good podcast purveyors everywhere. Hello also to you, but you can't see us. We're all looking magnificent today. We are joined, we are delighted to say, by a very special guest today in Kiri Pa. Kiri will be known to many of you. I know the numbers of people joining us today have exceeded our usual average, and I'll put that down to you, Kiri, because it certainly can't be explained by any of us. But to those of you who don't who haven't had the pleasure of meeting Kiri before, she spent more than 20 years as a construction lawyer, initially in private practice, and then 15 years as the Regional General Counsel for Arup, which is a large international professional consulting company. During that time, Kiri was involved in numerous large projects in the region, including Airport Link, Gold Coast Light Rail and Marina Bay Sands, the kinds of things which throw up inevitably, as any construction lawyer will attest, disputes of all kinds. She was on the board of Consult Australia, the industry body for consultants in the built environment, for 6 years and was their president from 2017 to 19. She was named as among Australia's most powerful part-timers by Women's Agenda, has been named numerous occasions by Doyle's Guide, and in 2020 has seized the opportunity to pivot and is now enjoying practice in her own consultancy, which is called
Kiri Pa.
Kiri Pa, the eponymous. So a welcome to you, Kiri. We're really delighted to have you here. To my immediate right and your left is Glenn Newton of Queen's Counsel. Glenn has a Masters of Law from the University of Queensland, where he was admitted to the Dean's Honour Roll for academic excellence. He's been a silk for 14 years, during which he's appeared in a vast range of high-profile cases. To name but one, he appeared in Wick in the High Court, has appeared in commissions of inquiry of a broad variety, commercial litigation of all kinds, and is now, interestingly, pivoting also into a greater participation in mediations. In this part of his career, he's been named as one of Queensland's leading mediators in Doyle's Guide on a number of occasions, and of course has been a very dear friend and colleague here in Chambers for the last 10 years, and as all of the juniors in this place will attest, is a great educator. So we're delighted to have him join us today. And finally, in the middle is Michael May. Michael's among the one of my colleagues here at Level 27. He has a broad commercial and administrative law practice. He's been named in all of the lists, but most importantly, he's one of the few junior counsel in Queensland who's been identified as a leading junior in dispute resolution in Chambers and Partners, which is a great credit to him and a testament to his real skill and ability. He's notorious for being a very capable advocate and a very decent human being, and indeed, and it gives me great pleasure to finally not be in the receiving end of this identification. He's a great musician. So keep an eye out for Michael. He's appearing with the Lorchestra Big Band in a few weeks' time, playing the guitar. So if you find yourself with a freezer Saturday night, Michael? Friday night, a free Friday night, do Google that and check out Mickey May and all the gang. We are here today, of course, to talk about commercial mediations. The subtitle is Strategies and Tips to Achieve the Best Outcome for Your Client. And if I can say something briefly about the rationale, this session appears as the next in a line of sessions we've hosted here at Level 27. We're attempting to do something a little bit more interesting than have a boring barrister simply talk at the camera for an hour, but to get a wide variety of perspectives on a particular topic. And so today, in talking about mediations, of course, Kiri brings to bear the perspective of having been a long-term solicitor, but indeed also having been the client in lots of dispute contexts. Michael's going to talk to the role of acting for parties in mediations, and Glenn, of course, is going to bring to bear his expertise in mediations as the mediator after a long career as a person acting for parties. Mediations, of course, it goes to say, are not litigations. They are part of it, but they are things which need to be approached with a very different mindset. Glenn, I wonder whether you might kick things off by telling us something about the differences you've observed about the way mediations need to be approached from that in which perhaps you might have approached things in the past as a litigator.
Well, your perspective is of course different, but I think it's really a mindset question for me, that litigation is obviously about advancing entrenched positions. And if you want to do that in court, well, of course, the court is your forum to do that. Mediation is not about that at all. It's about a proper assessment of the risk involved in proceeding to litigation, and perhaps coming to an arrangement to which you would not be able to come if you went to the court for a solution. And that's particularly important if you have or want to have a continuing commercial relationship go ahead between the parties. You've got a greater scope for a solution that will permit that to be done, whereas a court's very limited in what it can do. It can give a judgment for money or specific performance or whatever it might be, but it can't make a nuanced decision that would give effect to a relationship continuing. So I think for me, the single most important difference is you've really got to flick the switch out of litigation mode and into mediation mode. You're not there to advance entrenched positions. You're there to try to reach a consensus, which is a hard thing to do because you really have to persuade a plaintiff to take a discount for certainty and to persuade a defendant to pay a premium for certainty, if you like, but all for a greater good. So I think it's a mindset question for me. Just flick the switch out of litigation and into mediation mode, which I think is the important thing to remember.
Hughie, Glenn mentions entrenched positions. I think you, among this panel, certainly have real unique insight into how one goes about perhaps preparing people inside the client side to move them away from entrenched positions. Can you tell us something about how you go about that process?
Yeah, absolutely. And it's a really good point because mediations, they are an opportunity to get off that litigation track that you're on. And I've always been an advocate. If a door's open to get off the tracks, take it. So it's harder than what you think because a whole piece of the litigation is having a whole heap of people spending a lot of time in that entrenched viewpoint and trying to advocate their case. So there's a whole range of things that you can do that are actually about unpacking that when you're on that client side. One of the things, so I've got 4 thoughts here. One of them is you actually have to spend a lot of time making sure people understand the process, that what the mediation is. The lawyers are very comfortable with this world. It's their world. They know everything. But actually, there's a huge education process that you're always taking non-lawyers through. And it does take them by surprise. It can take them by surprise by how long it takes and how much time they might spend in breakout rooms by themselves. The other thing I've always tried to do is create teams that are willing to challenge themselves, to put their black hats on, to bring independent perspectives into it. So the more that I can have a team that doesn't get locked in groupthink, doesn't get locked into its own positions, is open to being challenged as it's doing its preparation work. And I've gone even as far as, appointing a second counsel to actually just give a black hat advice to make sure people are really ready to hear that answer, that it's going to go wrong, or it might not go in the way that they planned. You've got to spend time making people willing to engage, because if they're sitting there in that entrenched position, if you're walking into that mediation with the view of, oh, they're never going to change, we're never going to get a deal done, why am I even here? You're starting so far back from your starting blocks. And the other thing you've got to keep in mind is that on that client side, you've just got so many internal stakeholders to take along that journey. And the bigger the claim, the more people you have to take through. And some of them are very close and you can get them a long way down that path. And some of them are much further away. They might be overseas. They might be an insurance company, and getting them ready to engage. It takes a lot more time and thought than some people might think.
Michael, do those kinds of considerations feature into your preparation as counsel who might appear at a mediation when approaching the task?
Absolutely. I think a large part of what you do when you're preparing for a mediation is focused on getting a clear understanding of where the client sits in the litigation, what the risks are, what the prospects are, what evidence problems there are. But in a sense, a lot of that is kind of taken for granted. You sort of expect that knowledge will be there and that work will have been done. And then I think another part sort of picks up on what Glenn was saying, is where you focus on trying to come up with different options for ways of resolving the matter. So not necessarily just thinking about what the case is about and who's going to win, but what are some other ways that we could resolve this situation, or create a better relationship between the parties that flows on from this. And part of that, I think, is also trying to think about what the other side wants. And again, not just looking at the sort of causes of action involved, but the clues that you might get looking at steps taken or correspondence, positions taken along the way that might give you an indication about, what's really driving the other side's position, and how you can use that kind of information to get the best outcome for your client.
So Glenn, I know you've been a real advocate for trying to educate solicitors and indeed clients about the value in undertaking preparatory steps to ensure the increased chance of settling things at mediation. Given those things that Kiri and Michael have said, from a mediator's perspective, how can you best be assisted to assist the parties to use that information?
Yeah, it's a good question. I think my approach to it is that the mediation process itself is a little bit undernourished, a little bit underdone. And I'm really talking about the scope for preparation. Now, preparation is obviously an essential element in every mediation. And obviously judgment will determine just how much preparation is required for any particular mediation. But let's look at it with this perspective in mind. In litigation, you have the luxury of time. By which I mean your analytical brain has a lot of time, probably years if you were to start the action today, to switch on. You'll have a legal team who will be applying analytical thought to a case, and they will be the ones who advocate the entrenched position to advance the client's interests. But you don't have the luxury of time with a mediation. That's why it's such a hard gig. You have probably 8 hours on the day to persuade parties who have previously been in entrenched positions to, in the plaintiff's case, to give away its case, in the defendant's case, to give away its defence of the case, not have their rights determined in court, but instead accept perhaps a different allocation of the risk and come to some consensual arrangement. Well, that's quite a hard thing. And you don't have the luxury of time in that. That's why the preparation aspect, as Matthew mentioned, seems to me to be so important, because I think it's elementally a hard gig. So the more preparation you do, and how much you do will depend on the case. If it's the BHP takeover, you're going to have a lot more. If it's a dispute about whether there was a proper allocation in someone's will, well, that's a different question. But I think it's very important to recognise the elemental importance of preparation, and to recognise the limitation in mediation in that you have to have it settled in a very short period of time. And so you've got these warring parties who have to see that it's in their own interest to do that. So I think preparation helps, whether it's by way of position papers or whether it's by way of seeing the mediator in advance, of which I'm a great advocate. I think it's a very beneficial thing, particularly if it's a complicated case. See the mediator in advance. It's all confidential. Talk to the mediator about things that you think will be trigger points on the day, which will be important on the day. And they may be things which a mediator will not glean from just looking at the pleadings or the contract documents, which are colourless documents. Let me give you two examples, one a little more extreme than the other. Would I, as a mediator, want to know that in a commercial dispute, there is an imperative for the plaintiff to get money because it needs to refinance loans within a short period of time? Absolutely, I would want to know that, because that will very much identify for me the motivations of the party and its preparedness to settle. Now, I won't understand that from the pleadings, but someone needs to tell me that. And on a more perhaps controversial level, in a commercial case, would I want to know, for example, that the defendant was having an affair with the plaintiff's wife or husband? Yes, I would, not just for prurient interest, but because it will tell me that emotions have now been triggered, and emotional considerations entirely extraneous to the commercial dispute are now going to impact on this. And I'm going to have to deal with that in a way that manages to break through and stops the instinctive, I should say, and emotional thinking, and instead engages the analytical thinking about the bigger problem.
Can I interrupt there, Glenn? It's an interesting sort of point you raise about the emotional factors that are involved. And we talked about this the other day, Kiri, and I wonder if I can bring you in at this point. This process, mediation, arises in the context of an inherently black letter process. Litigation is typically that one part of the law that attracts people who like to think of themselves as black letter lawyers. But so much of what Glenn's just said, and indeed the things you said a moment ago, are not at all interested in the black letter part of things. And I wonder to what extent do we as lawyers give enough thought to assembling teams that have real capabilities in those emotional
Yes,
tasks?
and I'm all about the people, not about the law. And to me, it's the integration of those two things where I get results. I'm sitting here reflecting, going, one of the hardest things I've had to communicate or explain to senior executives is it's not a rational business, thoughtful process. You're often in litigation because there are some very significant human drivers sitting behind why you've ended up at that place. Someone's reputation can be on the line. Their personal bonuses are on the line. There's hubris involved. And they're highly emotional, and people are sometimes quite surprised that actually the whole process of litigation and claims often has an underlying very human behavioural story sitting at its heart. And one of the things that you need to be able to do with a mediation is actually unpack why the people are doing what they're doing. So to me, I've always gone into mediations thinking, if I can have my team as emotionally ready as they can to open up their thinking and to challenge their thinking, then I will engage in every single ADR process, mediation along the way, because I don't know at what point in time I'm going to get the mediator who's capable of breaking through what the people are thinking on the other side. And it's as much about their emotional journey as it is about mine. So the deals happen when both parties have gotten through that emotional journey.
I wonder whether it's something that you gained insight into by reason of having been in-house in particular, where you have a much greater proximity to the coalface of human beings in a corporate environment rather than lawyers who sit in buildings full of lawyers and don't necessarily have that insight.
Look, I think it's that, and I've had the experience. I mean, I was at Arup for 15 years, and my first job was negotiating the Airport Link deal. So I saw the people and the characters all the way through. And once you get that very long way view of why projects progress, you realize it's all about the people. The people drive outcomes in really, really strong ways. And the law, so to me, the law is a tool or a structure I use to get to the outcomes. And sometimes I think the lawyers are thinking, going, the law's the answer. Actually, no, it's a tool. And it is for me as the client to go, how do I best use that tool to get to the business outcomes that I want to achieve?
Naturally, we've got some things today that we came planned to talk about, but I should have mentioned at the outset, we're willing to take your questions, and indeed we encourage them along the way. We identify that one of the benefits of this interactive style of thing while we're broadcasting to you live is that you can ask us questions as though you were here with us in the room. One of the questions we've received, so please do feel free to chime in at any time. We're asked whether we could cover the strategies and tips on mediation that is not able to be done in person. Obviously in 2020, we've all increasingly had to embrace technologies like this because we can't be together face to face. Has anybody had any experience they'd like to talk about in that particular realm yet? Mediations conducted electronically, I think, is probably the question.
I have to say, I haven't yet done one via Zoom or electronically yet, but the people I've spoken to who have said that the dynamic is much different from doing it in person, understandably. I mean, we all know that so much of the mediation process is actually sitting in the room all day. You know, people get to 3 o'clock in the afternoon and start to get to the point where they really would like to just do a deal and get this over and done with. And I think to a large extent you lose a bit of that in the room feeling, and also the sort of the direct contact with people, you know, having someone, being able to speak to someone in the next room or, you know, in the corridor. I think you lose a bit of that.
Maybe Glenn has an example, because there's an exhaustion with being on Zoom all day, and that 3 o'clock factor, everyone's cranky because you need to stop the walkout, right?
Yeah, you do.
How do you get through that on a Zoom contact?
It's very hard. I've done them where it's both, where you've had people beaming in from remote places, as well as having some where the people are in the room. And I think, and in the same mediation, and there's a distinct advantage, I think, to having the people in the room. You seem much more connected with them. They seem to be much more willing to speak about things. They were accessible, you're accessible, whereas beaming in from remote locations makes it, by definition, more remote, and I think harder, and you do lose that intimacy, you do lose that connection. and that connection that you want to create between the mediator and the parties to lead to some sort of a breakthrough. So I think there's I agree with Michael, I think there's a distinct disadvantage to mediating remotely. Sometimes I accept it has to be done, but having seen mediations where they're both in the one, where you've got people there and people beaming in remotely, there was a distinct advantage in those cases having the people in the room, it seemed to me.
I've participated in mediations electronically, both as an advocate and also as a mediator. And I'd agree with that. I think there's no replacement. There's nothing quite like sitting in a room with people and eyeballing them. But sometimes it can't be avoided. And 2020 has certainly shown that to us. And I, for one, think we're going to see increasingly, particularly in low quantum mediations where people are in different places, clients insisting upon things happening electronically. To answer that question directly, though, I think if you're somebody who's preparing particularly parties for mediation to be conducted electronically, it requires us to use skills that typically we've never really been obliged to turn our minds to as lawyers. Every person who does this kind of thing has to channel their inner Cecil B. DeMille or Penny Williams. You have to think really carefully about the way you are presenting yourself and your client on screen. It seems a bit superficial. It's not something that lawyers, I think, naturally feel comfortable talking and thinking about, but you have to think about how you frame yourself up, the lighting in the room that your client's sitting in, what kind of microphone you're using in order that you can be heard effectively, because all of these things activate us in very human kinds of ways, it seems to me. And maybe you've got some comments for us about that.
And those things, as you point out, Matthew, ultimately are extra burdens.
They are, yeah, and require extra preparation.
They do.
And extra energy, and you have to be generous that sometimes people forget to turn the microphone on, and that's the number one thing we all say these days, your mic's not working. But if you can be generous around that space, but again, the emotional intelligence of your mediator becomes key, because if your capacity to actually read the room and to read the dynamics
is diminished.
So you have to spend more time in that space. It'll be a slower process potentially.
Yeah, it is.
Michael, I wonder for you, in preparing to appear at mediations, my experience often in being briefed to turn up to mediations is that you know what the litigation strategy is, but you find yourself in a mediation not really understanding what the mediation strategy is. And sometimes you wonder whether anybody's given that any real thought at all. How might those that instruct us, or you in particular, go about improving your ability to appear at mediation by better understanding what the client's imperatives are behind the scenes?
Well, I think a practice I adopt for pretty much every mediation I'm in, and I think a lot of people also adopt, is before any mediation, really, that if it hasn't happened already, the client should get some advice about the kinds of things we were talking about before, some idea of what the prospects are, some idea of what the possible outcomes in the litigation are. Obviously costs, because one of the main reasons why mediation is so successful is because of the cost of the alternative. I think a good process is to send a letter to the client with some information about that in writing so that they can sort of have that with them at the mediation. And then I think before the mediation, it's a good idea to have a conference with the lawyers, with counsel, if counsel's briefed to appear at the mediation, to sit down and talk about what the strategy is going to be, what the client wants, what kinds of things the client is looking for, to try and explore those things that we were talking about earlier, what kinds of settlement options they might be interested in. Often the lawyers won't really have a good grasp on that without asking the client. As you say, we know all about the ins and outs of the litigation itself, but so often there are other things sitting behind that drive the decision making. And unless you sit down and specifically ask about it, you're never going to know those things.
And there also, Michael, though, has to be a way of conveying that to the mediator.
That's right.
Because you give the mediator information. Information is knowledge, and knowledge creates a capacity to influence on the day. So you've got to find a way of getting that. And a way that seems obvious to me is either doing it electronically, linking up, whether it's an email, whether it's a telephone call, or whether it's actually getting together in someone's office or chambers to say, these are the things that are going to be influential for us on the day. And I suspect mediator that these are the points that are going to be influential on the other side, because, for instance, they need to refinance in 3 months. You don't know that, but I'm telling you they will. So bear that in mind, because you'll be able to use that. So you need to arm the mediator in a way that gives the mediator knowledge, because knowledge is it's a creator of a capacity to influence an outcome, which is what you want to do.
It's interesting you say that. Serendipitously, we've just received another question. Thank you. Which says, does the panel have experience of and strategies for dealing with a situation where the other side is not forthcoming with information, despite most mediations being conducted on a confidential basis? The things that we've just discussed really all seem to suggest that candour is a very useful thing in approaching mediations. But I mean, Glenn, do you, as a mediator, have a sense of whether things are more likely to settle or not if you extract that information, and how do you do it?
Well, you can do it by asking questions in private session to try to glean a position. Some of it involves a trust in the people who are appearing before you. That doesn't mean that they will necessarily relay what is the client's true position. I don't mean because of any deception on their part, but because the client won't necessarily confide everything in the lawyers. I mean, I've done mediations where through their counsel, for whom I had the highest regard, told me, and I absolutely believed it, there is absolutely no way that his client was going above a certain amount of money. Now, I took him at his word because that's what he had been told. And he was someone in whom you would have absolute faith. And in the end, because that figure wasn't going to be reached, or a figure in advance of that figure was not going to be reached, the mediation came to an end. The parties started to leave. Well, the other side started to leave. They went down the elevator, started to leave the building. Then this counsel, having seen them leave, or his client having seen them leave, came to me and said, I understand the other side is leaving. I said, yes, it is. He said, can you get them back? Because my instructions have just changed. So the bluff was called, and it ultimately had to be met. But the client did not put his counsel in the loop about what his true position was.
Kiri, from your perspective though, as particularly on the client side, were there occasions where, for deliberate strategic reasons, you withheld things from external lawyers or counsel until a particular point in time? And if so, why might you do that?
There can be complexity inside organisations that may or may not be helpful. And even inside the organisations, you might not know everything that's going on, especially if it's a large international and the positions of the subsidiary company can be different to the parent company. And there can be some other conversations that are going on that just are separate from what's sitting there in the claim team. So Michael was talking about, you've got to get together with your client. Yeah, a letter wouldn't cut it with me, I could tell you. We're having a workshop. I am building as much diversity at play, and hopefully it's facilitated, because I know it's a collaborative, diverse process that will actually pull out as much information and help me form the best strategy. That's playing the people game. I suppose behaviourally, I'm always on the side of taking a principled approach into negotiation. I think people who are principled, who are talking from facts and evidence and have a robust view, are more likely to get to the right place through the process. So I'm very rarely going to be somebody who's going to advocate for some hidden hiding hand sitting behind the scenes. But that said, there are things that are beyond my control that I might not know of. You might have one of the insurers in a tower who's selling that whole portfolio, and their number one job is to make sure as little money as possible goes out the door in the next 12 months. And that may or may not help things, and I may or may not know it. And certainly you can have differing opinions between different elements of a business about the right approach. Sometimes you've got to be very careful with that, because at the end of the day, it's the person who's closest, it's your executive who's closest to the deal, who's in the room, who's reading the room, whose voice you want trusted behind the scenes. So I don't tend to like it, because I don't, to me, it's inconsistent with being a principled negotiator, but things can happen.
Glenn, if you encounter in a mediation context parties who are reluctant to engage in that way, who are reluctant to explain to you what are the real drivers in the decision making, how do you
look for me? I suppose if you ask me to identify in a very precise way what mediation was about, I would probably say something like, it's about ensuring, this is from the mediator's perspective, that the risks have been properly understood and appreciated. It's about risk allocation. So I would normally, when you read the pleadings, you will read the statement of claim, for example, and you would think, well, I can understand why they're complaining. You'll read the defence and you would think, hopefully, if it's a properly pleaded defence, I can understand why they're defending. I can see the risks in both. Some things, the more experienced you become, some things you will read and think instinctively, well, that's never going to get up. Just because that's what your judgment tells you. And part of the role we bring to bear is a role of judgment. I just don't think that's going to get up before a judge. I think it's really about the risk allocation, Matthew. So you would want to make sure in private session that you play the devil's advocate. Say, look, I'm not sure what your position is, and you may not want to tell me. But for you, I see the risks as being A, B, and C. And I would always say, look, you're being advised by skilled lawyers, etc. You should rely upon them, because I'm a stranger to it. I've come into it very late. I have a limited knowledge of it. My knowledge is confined to what I've read and what you tell me. So your lawyers will have had a broader scope. They would have been in charge of it for some years, perhaps. So rely upon them. But have you sufficiently taken into account A, B, and C? Because the other side will say A, B, and C, and you have to factor that in to your risk allocation, because you might be wrong about something. And of course, you do the same for the defendant. The plaintiff's case is this. These are the points they're going to run. You might think that's a good point. That might be a bad point. But have you properly assessed the risk, and have you taken them into account? Can you afford just to stay loyal to your entrenched position, or do you need to think a little more broadly that you might be not right?
And to go back to the question about, what do you do when you've got a party who just is not going to give you any information about that? As Glenn says, I think as a starting point, you try to sort of explore why. I mean, they've come to the mediation for a reason. Hopefully they're there to participate in a sort of a good faith way. And I think you start by trying to sort of call upon those kinds of considerations to say, look, why waste the day? We're here. Let's try and use it productively. If that doesn't work, I think you then start to get to a point where there are a sort of range of different sort of deadlock breaking mechanisms that I think mediators can employ, which won't necessarily make the other side give any information, but can result in something productive happening for the day. One of the examples that jumps out is a mediator's bid, where if the parties at a point in negotiations where they're just too far apart and neither party seems willing to move, the mediator can say, right, well, what's going to happen is I'll pick a number and I'll tell each side what the number is. If one side is prepared to accept the offer, they will find out whether the other side was prepared to accept the offer or not. That is, the mediator will tell them, whether or not the deal was done. But if they're not prepared to say yes, they won't find out whether the other side was. So in a sense, that kind of a technique, and I've seen it sort of get deals done, because it's often the case that, parties in their offers are sort of moving towards a number, and people can often see where that's heading. But sometimes, the sort of loss of face involved in one side coming down or going up is just too much. And this can sort of cut through that. But even if it doesn't cut through, it can give you useful information, namely that, they wouldn't even go to that number, or they wouldn't come up to that number.
Look, I think I probably didn't answer your question completely enough. But one thing that occurs to me is if there is going to be a loss of face, you have to give the person a justification for the adoption of a different position. Often that will be because of facts that have been revealed during the mediation of which they may not have been aware before. That's a very easy way of adopting the change of position, because often if a decision is made in a corporate context, it's often made by a nominated person who might then get the imprimatur of the board, but it's that person's decision. So if they have to change it and get the board to sign off on a changed position, there needs to be a reason for that. The other way of making a breakthrough, it seems to me, Matthew, is to sometimes wean the clients away from the lawyers, without meaning any disrespect of the lawyers. But I've had very many cases where the clients were decent people, it seemed to me, as much as you can tell, at this sort of remove, decent people. You get them in the room, particularly if they've had a long association. You get them in a room together just as a threesome, just the mediator and the two parties, if there are two parties. And it's often the most productive part of the day, because I found that it's very, unless people are just grubby and are liars, but put those extreme cases aside, I found it's very hard for decent people to lie to people they know well. It just doesn't come naturally, I don't think. So if you've both been involved in negotiating a deal, and you and I will say, well, I remember, Matthew, I had a chat with you on a certain day. Remember we discussed what the discount rate should be? And you'll say, yeah, we did discuss that. I remember discussing that. And what payments we'd make with a discounted applied X if we paid them in advance within 30 days. Yeah, I do remember that. People tend to acknowledge the good points, I think, if you get them in the room together. Whereas the lawyers, as I said, without meaning disrespect, and I would never criticize a litigator because I've been a litigator for 30 years, but the lawyers, I think, find it difficult sometimes to get out of that entrenched me-in.
Yeah.
Whereas the clients have a broader perspective. Their perspective is really, I want to get out of this. I want to get back to running my business and making my widgets or whatever I'm doing. This is not the main game for me. This is a distraction. So if you can get me out of it sensibly, well, then I'd rather take that option and get back to the main game.
Can I ask the panel the question this then? Given that our topic is strategies and tips to achieve the best outcome for your client, assuming that the best outcome for your client is indeed settling it on the day, something I'm interested in, and I was thinking about in anticipation of this session, I was preparing for a mediation late last week. And one of the things we were considering was the degree to which during the opening session, or indeed throughout the day, we might reveal to the other side things which we considered to be either devastating or fatal to their case. And on the one hand, we knew that if we told them these things, it stood perhaps a greater chance of settling the matter. But once the genie was out of the bottle, if you like, we lost the forensic advantage of taking them by surprise in cross-examination at trial. Do any of you have a view about whether or not, given that the imperative is to settle, it's better to be entirely candid on a day like that, or to leave something reserved to yourself?
The barristers don't want to lose their big bear that they want to land during trial, do
Yeah.
they? Look, it would depend on the mediation, but I mean, I'm a really simple soul. To me, it's a story. If you've got a good, solid story to tell, there's always advantage in just telling that story. One of the things that I think you can do with mediations that's powerful is give the other side a perspective on the event that they possibly haven't heard from their own team. And once the relationship has ended up into a litigation process, there's not many opportunities where you're actually sitting down discussing the case, that you actually get to build an opportunity to understand or see the world from a different perspective. And that open plenary session where you get to tell your story, if it's a good story, I think that will always allow you to make progress. And sometimes that can be the first time the senior executives on the other side are hearing the world from a different lens. And it's a very, very powerful thing to do. But again, if you're sitting there going, it's a very complex process and you're allowing the lawyers to really dive into their entrenched position, and it becomes all about the big case they've created and to really lock their side into a big number that they've really ended up being stuck around. Because as soon as we put numbers around, we psychologically get hooked to them. And if a client's hooked to a really large number, you've got to spend a lot of time unhooking them from there. And from the other side, it's hard to do. But that opening session, to me, it's one of those, it's the starting of that conversation.
Look, I think that segues into a slightly different topic, and that may be the significance or not of the merits intruding in a mediation. And again, that for me is a judgment call. Having been a litigator for 30 years, as I said, you have some points that you will regard instinctively as being good and some that you will regard as being instinctively bad. And that's a judgment call. But I think merits do intrude a little. And if they're going to intrude, you can make them in that opening presentation. They only need to intrude enough to identify them as a reasonable risk, which the other side has to take into account. These are the points we want to run. We think they're serious, etc. So please take them into account in your risk assessment. So I think it's useful from that perspective. And as you said, Kiri, it may be that the people who turn up on the day as the client reps may be very senior people who have not heard the case put in that very brief encapsulated way, and it gets sometimes a shocked reaction.
Well, absolutely, and I see it plays out most on some of those very large corporate claims, which are global in nature, hundreds of millions of dollars, and actually they might have a good genuine claim. It might really only be for $10 million, but because they've spent so much time convincing themselves of their $100 million position, to me, when those dynamics are at play, I think you have to start with the merit conversation, because until I move the goalposts closer together, I don't even think we could start having a conversation about where we might land up. Because if you start with $100 million and every lawyer will say, you've got to allow it something, let's give it 30% merit, that takes you to a number that's just not a reasonable number for the valid claim. So sometimes your first job is to move goalposts, and then you can start negotiating.
We're asked a question, and it's interesting. Each of the questions we're taking are ones that are occurring to me on the way through. So I think we're communicating to the audience beautifully today. Something that occurred to me when we were talking before, and something Kiri said made me want to ask you, Glenn. You spent, and you've made mention to it, you've had a very long career as a litigator, and I think developed a reputation for being particularly tough, which is a very important quality in a litigator. But the process of mediation is different. And the question that's asked is, are there any common tactics used by lawyers in mediation that are particularly counterproductive to dispute resolution, and why? And what I want to ask you, because you and I are friends, I know you've spent a lot of time thinking about how differently one approaches mediation, particularly as a mediator. And I want to know whether there are things that you would have done instinctively as a litigator, which you see people bring to mediation now as a mediator, which are unhelpful.
Yes, I find it very offensive now. But a good friend of mine who's a very experienced litigation lawyer, and an aggressive one, when he knew I was some years ago that I'd segued into mediation, he said, "You're not a mediator, you're a litigator." Yes, I understand that, but I'm now going to be a mediator. But look, you do have to bring a different mindset to it. And again, I hark back to the entrenched position, Mian. If you come and say, we think we've got a very good case and we're going to win at trial, yeah, I understand that, of course. Of course, that's how you think. But we're here to discount that possibility a little bit legitimately. You must assess the risks and see whether you can sufficiently allow for those risks today that we can compromise. Let's test it in this way. Would you ever have, whether it's a barrister or a solicitor, doesn't matter, would you ever have a barrister or a solicitor sign off on advice to the client that guaranteed a victory in litigation? Of course you wouldn't. No one's going to do that. It would be stupid and negligent to do. You'd CC it immediately to law claims and to our insurers if you did that. Because there are too many variables. Witnesses go bad in the box, not because they're being dishonest, but just because they might be nervous or for whatever reason, or the judge doesn't like them, perhaps unfairly. Documents are produced late in disclosure, which put a different perspective on things. The judge doesn't like you for some reason. These are things you cannot control. And the litigation process is compulsory. You have to engage in it. Once you engage in it, you can't opt out of it. There are processes through which you have to engage. So I think, again, Matthew, it's the mindset of an entrenched position. You have to flip the switch to vaudeville, flick the switch out of your litigation mode into mediation mode, properly assess the risks, consider that you might be wrong, and put the black hat on, as Kiri said, and test it. Test your case.
What I have in mind is perhaps something like tone, though, because we've all had those experiences, and I certainly have one firmly in mind, where you go along to a mediation and you hear the person on the other side of the table make a very bellicose and offensive opening statement, presumably upon instructions, and it immediately puts everybody on the back foot, and it sets a tone for the discussion which is not productive.
Look, I think, and again, this is the judgment call about opening sessions sometimes. And I have had counsel, aggressive counsel, who have said to me prior to the session starting, this is a fraud case and we're going to accuse him of being a fraudster. So, well, that's not going to work well. I mean, you've either got to then exercise some judgment and say, well, look, I'm not going to have an opening session because I think that will be a disadvantage. But at least let your client know that the other side is going to react badly if you accuse them of being a fraud. for all sorts of reasons. And if that's what you want to do, then all right, you'll do it, no doubt, in your quiet moments. But it might be to the disadvantage of the outcome. And of course, you're never going to let people abuse people under the pretext of having an opening session. That doesn't happen. So you've got to control it. But I think you're right, Kerry. I think those sort of super aggressive positions can be a big disadvantage.
Yeah, I've had two thoughts if you said these things. Behaviourally, I've always disliked the walkout. I'm sitting here thinking, I'm here to engage. I've spent a lot of money. I'm going to stay here and be open for the conversation until we agree that we've taken it as far as we can. The walkout stunt, I think, is eminently unhelpful. And then I think the mediator really has a responsibility to set the tone. I've walked into a mediation where the mediator was reading the newspaper and he opened with, "This is going to cost you a lot of money, you better settle." And it was like going, I don't know what you were hoping to achieve with us or what impact you were wanting to happen, but you've set the wrong conversation for the entire day. And it was that is so frustrating.
I don't think playing the cost card is a novel point anymore. It may have been once, but I think we all know that.
Yeah, don't thump the table. It was it was still extraordinary, but it was so disappointing.
But it cast a pall over the day.
It cast a pall over the day. So the energy you bring into the day and that personal connection you can make and get people engaged in that conversation in a genuine way.
Look, it is an interesting question between being a proactive mediator intruding too much, and my view about it is that you should get into the arena.
Yeah.
This is the difference between someone who's a judge and someone who's a mediator. That's why I think the badge of a retired judge is not always a good one, because they were never permitted to get into the arena.
Yeah.
That's totally verboten to a judge. You can't do that. As a mediator, you've got to get in the arena.
Yeah.
You're talking to everyone confidentially to try to bring about a resolution. So the training is entirely different.
Yeah. It's you've got to work out why is this person ticking in this way? Why are they thinking this way? Why are they holding this position? And if it's genuine and flawed, you've got a really big problem. But if they're engaging genuinely and you need to test their thinking, you are so well placed as the mediator to unpack their thinking and to get them to shift. Even if they don't shift on the day, it still adds value.
Well, that's right.
But I need that emotional engagement.
Well, I think this is as I advocate, this is the fish rots from the head thing.
Yeah.
It goes wrong from the top, because it's up to the mediator to exercise some judgment. I was for a party recently in a mediation where the very skilled mediator, and I won't embarrass her by identifying her, she brought a party back 5 times. They were walking out 5 times. We had the white hat, I should say. But she managed to bring them back, and ultimately after a very long 2-day session and weeks of negotiations after the event, it settled.
Yeah.
But you do have to get into the arena and do the job. You've paid a lot of money to do it, so do it.
So I, on the other side, was saying, I respect that mediator for the hard work that they put in, because it is really, really hard work, but which is why also my position is you never leave until you've got to the very end.
Absolutely.
Because you never know what's going to move the other party.
No, that's right.
I think that's right. I really want to agree with what you say about the sort of the tactics side of things. Sometimes you see things like the walkout or things like that are just sort of unproductive, and you wonder why people do it. And the fact that you won't do it doesn't mean that they won't engage in it, but you can't really control that. But I've never seen it sort of create an outcome that's been better than it would have been otherwise. You know what I mean?
But this is what's so interesting about it, I think, is that if you think about it, mediation has still a relatively short history, at least in this jurisdiction. And there is an increasing level of sophistication about the process. I think in the early days, at least as I understand it from things people have said anecdotally, there was a lot of that kind of gamesmanship, and I use the word man deliberately because typically it was blokes who did it, I think. And that sort of thinking that people were impressed by storming out or making heavy-handed speeches in opening sessions. But there's a degree of sophistication, I think, which is now intruding in the mediation process. And I'm really interested about the fact that much of this discussion has been about things psychological and emotional and human, and not at all about legal tactics or forensic strategy. And I think that's something that is worth remarking upon, and I think it's something that we're all in heated agreement about.
And I don't think lawyers are particularly trained in this, and it's over the years. I mean, I know your paper, you refer to Kahneman's work. I've read that through this year. You talk about groupthink and optimism bias and halo effects and how we get locked to numbers. this is what's really going on. You've got to connect legal theory with social behavioral science. Behavioral science is if you can unpack that, you can start doing
because you ask, why is somebody thinking that way? And the answer might be because they don't have their analytical brain switched on. They've got their emotional, instinctive brain switched on. And that's understandable in the mediation context because it's such an abbreviated process in terms of time. You only have 8 hours. So, of course, people are going to be upset at some stage. Whereas with litigation, you've got the luxury of time to switch from that to analytical.
Well, I think the key thing, Kiri sort of touched upon it earlier, it's the integration between the sort of technical legal thinking, which, as I said earlier, is sort of taken for granted. You sort of have to have that covered, but it's by no means the point at which you can stop. You have to deal with the personal side, but that's where all the magic happens.
If you can have someone who can bring the legal piece, what those business goals are, what the people are doing, you'll get to a better place.
But there will be often a compelling legal point, perhaps, in a case. But often the legal points that people want to make in a mediation, I would just describe as, look, they're advocates' points. You can make them when you go to court. Understand what you say about that, but we've got to take a broader approach here. You might be right, and the only way you'll find out if you're right is if you go to court and a judge will tell you. But if you want to avoid that, then stop saying that. I understand the point, but let's see what we can do with the broader dispute.
I think there's some education that needs to go on about that, though, because for me as an advocate, often when I turn up to mediations, I feel very comfortable in recognizing and trying to address that human side of things, but you still feel as though there's an expectation by your instructors and by their clients that you're going to beat your chest and say sort of bellicose kinds of things.
That's why I think it's terribly important for the mediation process to be collaborative. It should be a collaboration between the mediator and the lawyers and the clients to try to bring about a resolution. So whether you do that, you'll do it on the day, but I think there's a great opportunity to do it in advance of the mediation so that you can work out as a mediator who's influential in this, who's making the decisions. Is this person timid? Are they genuine? Are they here to settle? Are they not? Are they just difficult? You get to form a view about people, which if you do on the day for the first time, you've wasted half the day perhaps.
And I think part of it's just explaining to the client that, as you said, you've got to explain what the process is about and how it works. And I think if the client understands what the process is, they'll understand that there isn't much point in trying to persuade the other side of your excellent legal point, because that's what the court's for. This is all about trying to best maneuver to get the best kind of agreement that you can get, and that's a completely different beast and needs a completely different approach.
Well, I mean, how often have we read, if you're the plaintiff, you've got your own wonderful statement of claim, but you read the defence and you think, they might be right about a couple of things. I mean, if it's not arguably good on its face, it'll be struck out. But if it's going to survive that, it's good on its face, and it must make you at least pause for thought.
Good, straightforward stories.
That's right. Yeah, that's right.
Always win out.
Yeah, that's right.
I'm conscious of the time, and we're getting closer and closer to the end of our allocated hour. I wanted to talk briefly about the future of mediation, and I mentioned that there seems to be an increasing sophistication around this process. What are the things that each of you, from your perspectives, foreshadow might be areas for growth in the future, and ways the process might be done better to achieve better outcomes for clients ultimately?
Well, we had the conversation we've been having about the emotional intelligence of mediators and the emerging behavioural science. So I think mediators are going to get much better and better at their jobs when they engage in the real people dynamics that are surrounding that role. My hope is that maybe we can have some kind of process that has that happen earlier, maybe even before the litigation has kicked off and we've gotten entrenched in, the extreme positions that litigation tends to take you to before you start narrowing and converging again as parties. So can we have some ADR, some really good quality ADR with properly explored claims before we've filed pleadings? That would be delightful.
Look, I think the way I would regard, what I regard as a big advantage with mediation is that it has the luxury of immediacy. It's an opportunity immediately to settle something on a given day within the space of 8 hours. I don't mean by that there isn't going to be some days of preparation for the parties. Obviously there will be. But it's the immediacy, the capacity to settle this very acrimonious dispute in 8 hours, I think is terribly compelling. Totally different scenario to litigation, which is advancing in transpositions that will take years to come on in the usual course, then be subject to appeals and all the rest of it. Yeah, but even if you compare mediations to, say, the arbitration process, the only things that it seems to me they have in common is the fact that you can choose your own panel, and of course you can choose your own mediator, so you've got that familiarity. And the other similar feature is it's confidential. But otherwise they're just totally different processes, because ADR, one of the greatest, arbitration, I should say, was always said to be, well, it was very cost effective. Well, it's not cost effective at all. It's very expensive, as we now all know. And it was very good in terms of timing. You could get it on quickly. Well, that's not true either. I mean, parties have waited for years to get things done and determined. So you don't have those advantages. You only have the advantage of being confidential, and you can choose your panel. But it's the immediacy thing with mediation, which I think is so compelling. This is a real opportunity to put this dispute to bed. Can we take it or not?
So I was just going to add that the only other sort of future perspective I thought about was something that came up from one of the earlier questions about the use of technology in mediations, and we're all getting more and more used to doing everything by Zoom at the moment, and I think more and more we're going to have to get used to doing mediations by Zoom, and I think it's really just up to the profession, I guess, to keep abreast of the changes that are there. I mean, at the moment, Zoom and those kinds of things are the technology. I imagine that there'll be developments in how those technologies work in a mediation context, you know, ways that you can mirror the in-person experience a little better, you know, sort of breakout rooms and things like that. I know there are mirrors of that in the technology at the moment, but I suppose the point is the technology is going to keep developing, and we have to sort of keep developing along with it.
Look, I think that's right. And that's a very helpful jumping off point, Michael, to one of the questions that I've received that hasn't been answered. And we can now answer it because it's the appropriate time. The question was asked about whether there have been any concerns about security or legality around using technologies for mediation. Obviously, we can't answer that at length in the short time we have available, even if we discussed it for the whole hour. But can I say this as perhaps the most technologically advanced member of Level 27 chambers? That's not saying much, I accept. There are technologies which are safe and secure. There is encryption available, end-to-end encryption, which means that unless you're sort of trading White House secrets, you can rest assured it's safe. Obviously, you need to do your homework behind the scenes, but in terms of legality, certainly from my perspective, there's been no difficulty about that. One other question we've had, which I think I'll answer myself in order in the interest of time, is there benefit in attempting to build rapport between representatives of the parties to the mediations? I think any advocate worth their salt would recognise, whether it's in mediation or litigation, fundamental to your role is to build rapport with whomever it's necessary to build rapport in order to advance your client's interests. And I personally have never seen a better outcome from a client brought about by an advocate who was not attempting to build rapport with his or her or their opponent. It's fundamental to the task. We've had a very broad-ranging discussion over the course of the last hour, for which I'm personally grateful. It's been great fun to have you all here in my room across this lunch hour. Can I first of all thank Kiri for joining us here today? It's an absolute, we're so fortunate to have you here with us. And you can come back anytime. It's just an absolute delight. Michael, May and Glenn, who are frequent visitors to my room, it's lovely to have you here in this formal setting. Can I say, we'd invite you to continue the conversation with us. I know each of us is on LinkedIn. Kiri's certainly on LinkedIn. You can make contact with her there. I know she'd love to hear from you. Glenn similarly is prolific on LinkedIn and would be very pleased to continue the discussion with you. Michael May is one of those voyeuristic types who pretends to be on LinkedIn. We'll probably ignore your messages. Level 27, of course, is on Twitter. Come visit us there. This will be on YouTube in due course. It won't be immediately available, but we'll send you an email as soon as that goes online. We'll also send you an email with some really interesting papers that I know Glenn's written and I've had the benefit of reading, and I know Kiri has too ahead of this session. I commend those to you. Thanks very much for joining us. Again, if you're watching us via Zoom Live, we hope you enjoy the rest of the day. It's looking a bit grim outside here in Brisbane. If you're on YouTube, hi, hello. If you're listening to us while driving along or commuting in the podcast, thanks very much for joining us, and we look forward to seeing you when next we convene here at Level 27. Thanks very much.